Minhas amigas e meus amigos, voltamos mais uma vez pelo Warde Advogados, desta vez em mais um episódio dos nossos temas sobre arbitragem e com um convidado internacional. Eu e Renato Polilo, meu querido sócio, meu amigo, recebemos hoje ninguém mais, ninguém menos do que Joe Profaizer. Joe Profaizer é um grande arbitralista com enorme experiência internacional, é um advogado sócio do escritório Paul Hastings e professor de arbitragem na Georgetown University, na Faculdade de Direito de Georgetown, da Universidade de Georgetown. Joe, how are you, my friend? Very nice having you. Thank you so much.
Good morning. Good morning. Great to be with you, and greetings to everybody who may be watching this now or later.
Thank you so much, my friend. Renato, bom estar com você de novo, meu querido. O Renato prazer, é o grande organizador, é o mentor desse seminário. Obrigado por trazer o Joe e podemos falar sobre o tema de hoje. Nós vamos falar, basicamente, sobre a cross-examination na arbitragem internacional, que é, basicamente, uma forma de inquirição e de revelação da verdade material para os árbitros, para o juiz da causa, que é bastante diferenciada da nossa tradição, não é, Renato? Bastante apartada da nossa tradição, na qual o magistrado, e em que pesem as modificações recentes do Código de Processo Civil, com o advento do novo Código de Processo Civil, o magistrado ainda tem uma posição de mediador nesta coleta de provas, por meio da qual o advogado de uma parte, ou de uma das partes, faz perguntas à testemunha, não é? Ou então à própria parte. Não é? Na tradição anglo-saxônica, isso é diferente. E, sobretudo, no contexto da arbitragem internacional, a participação do advogado em relação direta com a testemunha e, portanto, com a fonte da prova, é muito mais, entre aspas, agressiva e sujeito a uma dinâmica completamente distinta. E é sobre isso que nós vamos ouvir o Joe. Joe, I was just explaining to our audience that you are going to talk about something that we do not have in our legal tradition, that we are very much excited to learn about it because cross-examination is a new reality in our domestic arbitration. Lots of panels use it as a technique to unveil the material truth, you know, in a direct relation between lawyers and witnesses. So we'd like to hear from you, for you to explain to us and to our audience, what is it? What is cross-examination, my friend?
So thank you very much, Walfredo. Thank you very much, Renato. It's great to be with you this morning. My apologies that my Portuguese is a little bit rusty, and so I won't be able to communicate with you all in Portuguese, but I'm looking forward to a lively, robust, and interesting discussion on these issues. And when I say these issues, let me give, just to kick off our discussion, sort of 3 points about cross-examination in the big picture context, and then we can drill down on any aspect of them in terms of what you want to discuss or take it another way. So none of us like a history lesson, but all of us need a history lesson, if you will, sometimes. So I'll make it conceptual, but nonetheless a little bit historical, at least from my perspective, and this is just my perspective. Cross-examination goes to really 3 critical issues in terms of the entire judicial process, the entire arbitration process, the entire process of what we as human beings have come to see as the search for truth. And that's what we're all looking for in our institutions, as well as in our individuals, as well as in our cases when those individuals and institutions clash with each other over a dispute. So I think cross-examination, from my perspective, arises from sort of 3 different ways, although you could summarize them more or expand them more, and I'm sure we will. The first is the concept that I think exists in every single legal system, which is the concept of due process. That there be a process by which the parties agree and they find that they will find the truth, or they will find a resolution. Sometimes it's just a resolution and not the truth, but find a resolution to issues that face them in terms of disagreements. So the first is due process. The second, I think, is evidence. And that is that the process of cross-examination is designed to develop evidence that we as lawyers, or even as non-lawyers, are looking for in order to adjudicate and to resolve those disputes. And so what cross-examination does is, we'll talk in a more mechanical way later, but I think cross-examination has been at the heart of many of the Anglo-American systems, because it's another way by which we create evidence for the fact finders as well as for the parties to have that material by which they are going to resolve things. And then the third thing is being very, very honest, and also, frankly, both a little fun as well, is it's a lot of show. There's nothing like, if you've seen a great or even sometimes a bad American movie, and we can talk about our favorite cross-examinations later if there's opportunity to do so, if it's a great movie or whether it's a great television show, actually, through a few great moments that I've lived in live that could have been filmed on TV or a movie or whatever, it makes our job a lot more interesting because we're active and we're engaged, and there's this element of both drama and unpredictability. And you have to contrast that with sort of the element of process. And so I would close, if you will, from a conceptual point of view, you begin with the process, which is supposed to be predictable, methodical, systematic, and yet you end with cross-examination, which introduces this fascinating, fun, and very dramatic sometimes element of perhaps surprise, as well as both surprise as well as resolution of the issues, because a witness does or doesn't admit something. So maybe we can kick it off with that, and we can also have a good discussion about how the common law and the civil law see those perspectives differently. But those are three, to some extent, universal truths about cross-examination that may get us started.
But Joe, tell us how it is. Describe to us a little bit, because in our tradition, our audience, the lawyers in Brazil are used to the fact that the judge is sort of mediator between lawyer and witness. Okay, and also the judge decides which questions he or she will make to the witness, and may decline to make some questions. But in cross-examination is different. How it is? Tell us.
So why would you want a judge to ask your questions when you get to ask the questions yourself? I can't imagine that as a common law lawyer. Why would I not want the control and the confrontation with the witness to face the truth, or to face the lies, or to face the perspective somewhere in between as to which one of those? So I would say back in a fun way, why would you ever want a judge to be a mediator? That's his or her ultimate job. You want to be in the battle. You want to be presenting your own case. You want to be confronting and controlling your own case. Why ever turn that over to a judge? And so, and by the way, not only you want to turn it over to the judge, why don't you not only want control over yourself, but why would you want the referee in a football game to decide the game for you? That's not the purpose of the football game. Each side should have an opportunity to robustly present their case, and one of those mechanisms is through confrontation and control. We can talk a little bit more about those methods as we get to it, but that's really the element of why movies are made out of this, because there is confrontation and control. Doesn't mean it's always interesting, but it is confrontation and control, because there are a lot of uninteresting things that have to happen before you get there. But so it really is there are moments, if you will, like you see on shows, but there are also a lot of more methodical and plotting moments, because any great cross-examination is built on a solid foundation of that preparation and understanding of the record.
Before we talk about techniques and the preparation, I think that Renato has many questions about that. But let me ask you one final question before I, pass the ball to Renato. What are the limits? What is the line the lawyer should not cross in cross-examination? How much can I smash a witness before, the judge says, you crossed the limits, guy?
Great question. Great question, because the search for truth and the search for resolution within the process that is established always has both opportunities and limits. So you frame the question beautifully. So let me give a few guidelines, if you will, from my perspective. Although the first rule of cross-examination is always to get to the truth, you have to do that in a way that A, respects the process, B, that respects the witness, and C, respects yourself. Because what you don't want to be doing is badgering a witness. You don't want to be engaging in conduct with the tribunal that is not helpful to the tribunal, or engaging in conduct ultimately that, especially from a common law perspective, is not ultimately beneficial to your own client. So keep in mind, by the way, that one of the beauties of the battle is that not only do you get an opportunity to cross-examine, but they will as well. So you have to keep in mind that reciprocity, that golden rule, that Kantian categorical imperative, however you want to think about it. And you have to keep in mind that you always want to respect yourself, your client, the other person's witness, the other side, and the tribunal. And whenever you are, although it's highly fact intensive, violating one of those principles, then you're probably not conducting the cross-examination in the way that's most efficacious and useful to everyone.
Great, great. Renato, I would, make questions forever to this guy, but I will give it to you.
Oh, thank you, Valfrido. So, Joe, I was thinking here, like civil law lawyers like me and Valfrido are used to the judge taking the lead on the examination of a witness. So from the perspective of a civil law arbitrator who used to this type of system, sometimes I think the common law lawyer's cross-examination may be perceived as an effort to trick a witness. So I was wondering here, how do you prepare yourself when you have a hearing, knowing that one or more arbitrators are from civil law jurisdictions? How does it work?
So you've got a lot in there, so let me unpack it and then we can explore any other aspect that you'd like. The first is just as a common law lawyer, I have to start, I apologize, but as a natural reaction is to your idea, and I very much appreciate it. It's fascinating and deeply appreciative that somehow the purpose of cross-examination is to trick the witness, when in fact, the purpose of the cross-examination is not to trick the witness so much as to understand what the witness's perspective is. And if you have a good judge, if you have a good arbitrator, if you have a good set of panel, if you have a good opposing counsel, they will both, in that battle in the marketplace, as the US Supreme Court has said, in that battle of the marketplace for ideas, they will be able to see ultimately what is real and what is not. So you shouldn't underestimate, and I know this is a civil law perspective and I very much respect it, but you shouldn't underestimate your own abilities, the judge's own abilities, to be able to discern exactly what the product of the cross-examination is going to be. That said, of course, like all stories that we all know as lawyers, there are a couple sides. So what I tell my witnesses in terms of preparing them and in terms of presenting is to tell the truth, and always to tell the truth, and to make sure that you are doing that as a first and second rule. Sort of like there's a famous movie here called Fight Club, where they say, what's the first rule of Fight Club? And the answer is, there is no Fight Club. And the second rule of Fight Club, there is no Fight Club. So the first and second rules are to tell the truth from your perspective as you understand it. And so if you take those rules, both to tell the truth as well as to tell it from your perspective, then you will be able to assist both your own client as well as the process. What I would tell civil law lawyers is, and again, this is very much a difference in approach. And so I'm not giving any advice, if you will. I'm only sharing my own stories based on what I've seen. And there are, of course, millions and millions of stories that everybody has. So people will have different perspectives as they prepare. But what I would say to civil law lawyers is, don't be afraid of learning this process, because once you do, I don't think you'll ever want to go back, because you will then again have that control over your own story. And while the judge remains the pivotal person, they're not mutually exclusive. The judge can still ask questions. The other side will still ask questions, but everybody gets into the ring. So don't think of this as an either or. Think of this as both.
Great. I'd like to continue on that because, as you know, Joe, we have some limits and some rules to deal with witnesses before the hearings. We cannot, it's illegal if we ask witnesses to lie, for instance, or even if
And I think that's a universal. I think that is a universal truth, right?
Yeah, but there's a difference, a subtle difference.
Yeah.
There's a subtle difference between asking someone to lie and just cleaning up a little bit a narrative. So and it's a subtle, it's a very thin difference between the two things, because you can ask things without saying things. There are rules for that kind of preparation in international arbitration.
So there are rules, but they are very much dependent upon the jurisdiction, depending upon the tribunal, and depending upon those actors in the ring. So as a result, while I would suggest there are certain rules, they vary from case to case. And I would be remiss to start to say what the rules are. So that is one thing that I would be very hesitant to set down, because although there may be rules like with the ICC, like with the LCIA, or with the American Arbitration Association, or whatever the arbitration rules are, or the procedural order that tribunal set forth, the rules vary right now, very much so. And so I would say right now, this is very much an area, and which is why this is such a great topic. And so congratulations to you all, Renato and Walfrido, for even raising it. This is an area that very much is in flux, where there are very few universal rules. And so that is, I think, what we have to keep in mind. I know it's not a very satisfying answer, but for now, it's the right one.
Great. Renato?
Yes, I have another question here, Joe, and I'm just curious, because under the procedural law of many civil law countries, the representatives of their parties are presumed biased and incompetent to testify. So how does it work? How does it sound to a common law lawyer like you?
That the idea that the advocates are biased?
Yes, exactly.
So, you know, I've studied in a number of different countries and had the opportunity to work in a number of different countries. And again, from my perspective, having both trained as an American lawyer, grown up, and will always be, if you will, have that American perspective, we all do, right? From our own countries, we are homegrown in many different ways. From my perspective, this is just my own personal perspective sitting here today, right? Because I'm also aware, by the way, of a great irony, which is somebody may use this video someday to try to cross-examine me, right? Or us. And so what I would say, though, in terms of striking that balance is again, what you asked, the advocate is an advocate, but the advocate still does have an obligation to the tribunal and to the court and to the fact finder, and those factors are balanced. And so what I would continue to say on anything in life, but particularly in something where there is a clash of views, is there must be a balance. And so the advocate can absolutely be biased, but they can also uphold their higher duty to the truth and to the tribunal. So I don't think they, as a holistic approach, have to be a choice. And so we can have that debate. We can have that, is the advocate biased? And the answer can be absolutely. And you can ask, well, does that matter at the end of the day? And the answer is well, both advocates are, quote, biased. They are ventilating and presenting their case, but they also are doing what is necessary to protect the system and to ensure the right result in whatever the case may be. So I would say you don't have to have it either way. You can still have it both ways, even though you respect the fact that at any given time, one party, one advocate may absolutely be pursuing truth as they see it.
Great. Joe, in terms of preparation, of course, you have a dual task because you have to prepare yourself to take the truth from a witness that is resiliently trying to cover it. And you have to find a way to pierce that, that shield and take it away. And you also have to prepare your witnesses to explain to the tribunal in a clear and objective manner. And how do you do it? What are the techniques and tips that you would give to our audience? How you do that?
So think about a football game, right? Great Brazilian football, right? And how that football game would play out. You have, exactly as you said, Wilfredo, you have three actors. The first is yourself and your side. Then you have the other side and their witness. And third, you have the referee or the adjudicator. But just like in a football game, it's not just one side, the other, and the referee. You have individual players in a football game. And so you are, again, on each side. Think about it this way. And I'm trying to give everybody a framework, right, of how to think about it or how I think about it. And that is amidst that triangle, off of that triangle, you have another set of three parties. You have your own preparation, you have your witness, and of course, you have your client. So at the same time, you are not only a pivot point between your side and the other in the tribunal, but you also have this internal pivot point where you're balancing the client's interests, the witness's interests, and your own interests. And when I say interests, I'm talking about preparing. So in terms of that preparation, the first most important lesson is, again, to balance. Balance, not just, you can't just have a single football player on the team who's going to win or lose the game. You have to have everybody working together in order to have a win for your side. And so in terms of tips, the first lesson is allocate the appropriate responsibility to your witness, to your client, and to yourself, and make sure that you're balancing those factors. I'll pause there and we can take that in whatever direction you want, but I wanted to frame that because that really is a resources question about what time do you have and how much energy will you expend, which is really the control that you have, because that's what you're thinking about in the first instance is, how do I prepare my side? And then how do I prepare my side vis-a-vis the other side and then the tribunal? So in terms of preparation, that's really, I think, the critical thing, because you need to be balancing all those files there, and you can take that, we can take that in whatever direction you want.
Are there certain techniques that you can use and that the doctrine and the literature about cross-examination presents to you of how dealing with how to deal with the witness during the cross-examination, how to perceive the psychological characteristics and how to use it for your purposes and interests? What are those techniques?
So the witness, again, understanding that rules vary. And we are very much in a process of flux. And every attorney differs, every system differs, every case differs, every judge differs, every arbitral tribunal is different when it's made up of different individuals. That's the fascinating part of what we do every day. But I would suggest, in terms of what do I do to prepare, you begin with a few, if you will, specific actions. So let me give, while I'm not giving advice, let me give a few things. The first is to understand the overall facts of your case by looking at the pleadings, by examining and understanding the pleadings and the submissions in a very detailed way. Now, of course, in some jurisdictions, maybe the witness can't review the pleadings or can't review certain things. And of course, it's subject to whatever those jurisdictions' rules are. And that has to be respected and is respected. But so the first thing is to understand those pleadings and to look at the pleadings and to review them. The second tip is create a set of documents that are critical documents that witness must know. And they will either know them because they will have lived them, again, depending upon the jurisdiction and depending upon what rules and laws are permissible, but for them to look at those documents and for them to understand the key documents, both what is core as well as what is handled. And so you should collect a set of documents and give them to them, including the pleadings to the extent it's permitted, including the core documents, and then including other documents that may not be asked about but are important for the context and understanding. And then the third thing is I would strongly suggest that before you go into any witness preparation, you make sure that you understand those documents yourself and you see how those documents and those pleadings and that witness fits in. And so let me end with that principle, which is each witness is his or her own actor. And so you can have a dramatic moment with a small actor. You can have a dramatic moment with a big actor. You can have a boring big actor where nothing really happens. And you can have a boring event with a small actor where nothing really happens because there's such a small piece in the puzzle. But in terms of actual preparation, they ought to be looking at the documents, understanding the case, and you ought to be planning your witness and preparing your witness just as you would your overall case. Again, understanding whatever the limits on the jurisdiction are, it's on the rules, your ethical and professional responsibilities are. So all of that is always an overhang in terms of preparing your witness.
Great. Renato, I'm stealing all your questions.
No, that's great. They're very good questions, by the way. So, Joe, like you and Valfrido said, you have several books and even courses in the US law schools on cross-examination. And I'm not sure if those books and courses would predict that we would be facing a COVID pandemic like we're facing right now. So I would like to hear your thoughts on cross-examination in virtual hearings that we're having right now here, mainly in Brazil and of course in other jurisdictions. What are the challenges for those cross-examinations virtually?
That's a terrific and timely question. And so we all feel, and I look forward to hearing you all's views as well, and I'd welcome them. All feel because of COVID right now that things are totally different. My own personal view has been that anything that's totally different, that feels totally different like this, still has elements of what's common. And so our virtual hearings, one of which I had a 2-day hearing just 2 weeks to 3 weeks ago now. Are virtual hearings new? Well, yes, and well, no. So virtual hearings are an entire subject in and of themselves, but let me address the cross-examination, because we had cross-examination in the hearing that I just did. Let me offer 4 points in terms of sort of cross-examination at the time of COVID-19, because by the way, there will be a COVID-21 perhaps, right? There may be a COVID-22, right? There will be other times, and the foundation for any period is built upon the other. So the first thing I would say is, in the United States, for example, American lawyers have been conducting telephonic depositions for decades. So we have this process of depositions, which we can go into or not, but those depositions are usually live. But when I was a young associate, one of the first depositions I had to take was telephonically because witness location when they needed to. And so a telephonic deposition is not new, or a telephonic period of questioning is not new. And so while it's not as ideal as having a witness live, perhaps, that telephone deposition can still generate that evidence that we've been talking about. Here, we live in the beauty of, I don't want to, promote any particular software, right? But we're living in a period right now where we can actually talk live like we are today. I mean, it's really a miracle compared to what existed 20 years ago or 30 years ago. And so what we have to think about is how does that change? How does cross-examination change, taking a step back from what would be live? And so while some of the things are very different, that literally everyone's not in a room, in many ways, you still see exactly that witness on camera. We can talk at your desire about security issues, but you still are able to present witness documents to that witness, but you have to do so in a remote way that may affect the element of surprise at some point. So you need to think about what is the same and what is different, and how are you going to deal with the witnesses? How are you going to deal with the tribunal, the documents, and how are you going to deal with yourself in terms of how you present it? So let me leave it at that, and we can take that in whatever direction you want. But I would say that everything's the same in some ways, but there are a few critical differences that you have to adjust for. Especially, by the way, in the international context, when you have translators and critical linguistic differences that you have to also deal with. So that adds another layer of complexity that makes our job both more challenging and more interesting.
I don't know if you realized, but I have a little tickle in the sole of my foot. And while you were speaking, I had the opportunity to scratch it a little bit. How would you deal with body language with virtual hearings?
Well, I can't see your foot, right? I can't see your foot, and I can't see if you have another screen, by the way, right? Where Renato is really the one that's telling you what to ask, right? Or I can't see anything beyond that little, as I like to say, frog in the well, right? All I can see right now is that little tiny, piece of the sky, if you will, as the Chinese idiom goes. And so in terms of body language, cross-examination always has that presentational element to it, that show element to it. And so the screen is smaller. That's the way I'd frame it. It's a great question, one that I hadn't thought about before, but the screen is smaller. And so in some ways you have to control more, but in some ways you have to control less. So I might not see that tickle in your foot, but I'm also going to get a much closer headshot as to what I am going to see. And then the other side, each side has to evaluate whether that actually lends itself to getting better evidence, developing better evidence, developing more truthful evidence, what it might be. So just like in anything, like in a football game, you're going to adjust accordingly. So I think body language becomes both even more important for what's on the screen, but you also have to monitor what's off the screen.
And do you think that the virtual hearings will be there after the pandemic?
Yes.
I mean, it's much less, expensive than gathering everybody in, one country and all those expenditures that are involved. I think that that's the future, don't you think?
Yes. In a word, yes. They are here to stay. They add another dimension. Just like a scooter. We see in the United States these scooters on the sidewalk all the time right now, right? Some people think it's a silly way to travel, a dangerous way to travel, and some people don't use any other mechanism. But you know what? Video conferencing, not just video conferencing, but video hearings are here to stay, and they are the future, no question in my mind.
Great. Renato.
Joe, I think that's great. And, knowing your background and knowing that you're from Texas, a state that I love. I used to live there, as you know, I lived there for a year or so. Do you have any recommendation? Most of our audience here is composed of law school students, Brazilian law students. And do you have any recommendation for them on terms of cross-examination and in terms of arbitration in general? Most of them are very willing to hear your thoughts, mainly because you're the chair of international arbitration at Hastings, a big law firm, and also because you're a professor at Georgetown. So do you have any thoughts for them?
So while those may be great current titles to have, or titles don't really mean anything, let me tell you that the most fun days in the wild west of Texas that I ever had in terms of cross-examination were in depositions in Texas, where you had no judge present and you had lawyers who were wearing cowboy hats, both literally and figuratively, and wearing boots literally and figuratively, and then doing a whole bunch of things with the wild, like a rodeo. Okay. So I saw a lot of early rodeos in the first 3 years that I practiced there, and it was great fun. And I've never, ever found anything in some ways more enjoyable than hearings and depositions for that reason, because of the element that I saw originally in my days in Texas. So the lessons I would say is that things can get pretty crazy down there. They can get crazy, but they can also get crazy in Hong Kong or London or Paris or Sao Paulo or wherever the arbitration may be held. And so in terms of things, in terms of lessons, if you will, what I'd say is to embrace the process of asking questions and thinking about how to ask questions, and not just knowing the record, but knowing how to ask step by step, exactly what you need to know. As another tip, if you will, another tip is to make sure that while there's a fair bit of show, you don't ever want to be, like we say in Texas, all hat and no cattle. Okay. And so you don't want to be all for show, and you don't want to be all just for plotting. You need that balance of things. So I saw in my early days that you'd want both a little bit of drama and a lot of preparation. And so that's where I started. And you'll remember the drama rather than the preparation, but the preparation allows you to accomplish what you want to accomplish for your client. I hope that answered your question.
That's great.
Wonderful.
No,
wonderful.
Wonderful. Yes.
Wonderful. Great. Joe, we have almost 1 hour of, transmission, and I loved it. I think that Renato, by the smile on his face, liked it too. And I hope you liked it.
It was great. And I would love to hear not just questions from you, but if there's an opportunity here and now for you all to share other perspectives from the civil law or otherwise about things that you think the future entails in both Brazil and internationally from a civil law perspective. So if I could turn the tables for a moment and ask you, what do you think the future of cross-examination is in Brazil and in international arbitration in Brazil as well?
I think it's we have a whole new thing ahead of us. We were, limited by the fact that we had the judge to, make some mining of questions and subjects. And just recently, because we have a new civil procedure code, we can ask questions directly to the witness. And I really think that, this is much better to unveil the truth. And it does not compromise, safety or the protection that the witness has to have, because the judge is there. And if I cross the limits, the judge will tell me. And I can, act as a professional and as a person to another person that maybe contains information that is crucial, vital to, present the truth to an arbitrator or to a judge. And that's, an evolution and development, a very good thing for our practice. And it also requires lawyers to prepare themselves to understand the techniques that are involved, because we did not have the chance to learn it in law school. We don't have, a class on cross-examination in law school. And I think that law schools will have to adapt, and professionals will have to learn how to deal with that, with the techniques that are available, trying to transplant those techniques to our reality. And of course, at the end, will prevail those people that are, ready to adapt, those people that are connected to people, because if you don't understand people, you won't be a good cross-examiner. You have to understand people. You have to read from, the gestures and the smile or the face, the body language. And also you have to deeply understand the facts of the case and the position and the role that person that you're examining plays in this whole picture. And I think it's a new brave world for us, and it's great to hear from you because we understand that we are going in the right direction. What do you think, Renato?
Well, Frida, I totally agree with you. And, I think the dynamic of our hearings is going to change a lot. It's already changing, of course, but it's going to change a lot. And that's why it's so important to hear from a common law lawyer who's used to that, who's used to this system, and help us to achieve those goals. Because at the end of the day, we always want the same thing here. We want the truth. That's the main goal here. And preparation is the key, of course. But like Joe said, you always want some drama. It's also important for that. And when you have that, I think that's perfect. Like when you can have both. And being from a Latin country like Brazil, this is great. When you can have both, that's heaven for us. So thank you again, Joe. That's really nice to hear your thoughts. And thank you again for accepting our invitation. I really look forward to seeing you in person very soon. And it's always a pleasure to have you here. Valfrido, thank you again.
Oh, I thank you. I'd like to hear the final comments
sure.
from Joe, and to thank you, Joe, for your kind answers to all of us.
Well, I want to thank all of you there, both in front of the camera and behind the camera, so to speak, at your law firm, because you really conceived of a great idea here in terms of the entire program. And I'm so honored to be a part of it, to have this discussion with you, which is really what the cross-border practice of law is about, is to be able to have these kind of conversations that make us richer as lawyers and that make our clients richer as well. So I just want to thank you very much for the opportunity to have this discussion and understand a little bit more about not just cross-examination, but the entire process that's developing in the United States, in Brazil, and across the world. So thank you for developing this cutting-edge set of programs and for looking towards the future. So thank you both, Renato and Walfrido.
Thank you so much, Joe. Thank you. And I hope to hug you personally in the future, my friend. Thank you so much.
I look forward to it. Thank you. Thank you all.
Thank you. Joe, thank you again, and look forward to seeing you soon. Take care, my friend. Um abraço.
Um abraço. Bye-bye.
Bye.